Hey everyone, Harry here to talk about Jack Smith's superseding indictment in the January 6th case. A lot of stuff to discuss here, but I'll try to really break it down and summarize the highlights. Let's start with it is a superseding indictment. So technically, when you're winnowing down an extant indictment, you can do a superseding indictment that just eliminates some things. Here, though, while they are mainly winnowing down, they revise, rephrase, and anyway thought it the right course to bring it to a whole nother grand jury who had never heard any of the evidence. So in a sense, that makes 5 grand juries, the 4 cases in Mar-a-Lago, Georgia, New York, and now 2 here who have returned significant indictments against Trump. All right. How is it changed? Let me give you broad strokes, explain the broad strokes, and then double back a bit. In broad strokes, it does 3 things. It eliminates the new indictment. It is now 36 pages where it was 45. It eliminates the whole scenario involving the Department of Justice, the toady, Jeff Clark, and his efforts to kind of leverage an improper relationship with Trump that went over his superiors' heads to force them to write the officials in Georgia and tell them that DOJ suspected fraud in the Georgia electoral returns. And as Trump said, my buddies in Congress will take care of the rest once the chaos would start to flow. That whole episode is out. I'll explain more in a moment. The other thing that is out are his Trump's discussions with White House counsel. So Pat Cipollone and Pat Philbin, Deputy White House counsel, they testified January 6th. They testified in these grand juries without having the benefit of executive privilege, had probably some very strong stuff to say, but that is all out. And then the final big change is not a deletion, but a revision to make this as much as possible about Trump, the candidate, Trump, the private citizen, a role that he occupied at the same time as he occupied the role of the presidency. So we have again and again, the very beginning of the indictment, for example, now says, the defendant, Donald J. Trump, it used to say, was the 45th president of the United States and he lost the 2020 election. Now it says he was a candidate for president of the United States in 2020 and he lost. That's obviously just a cosmetic change there, but it follows all the way through. Those are the 3 big changes. All right, why these changes? So now we go to the Supreme Court decision on immunity, which was exceedingly broad, and the mission now that the superseding indictment is meant to satisfy is to tack around those parts of the indictment that the Supreme Court indicated were improper because Trump either would be immune from the conduct, you couldn't make a criminal case out of it, or his immunity would require the excision of evidence, because in the Supreme Court's sort of tortured reasoning on this point, if you can't charge him on it, you can't even sort of bring it up in court. And the court, recall, said certain things are core official acts. Then there are a lot of other things that are official acts out to the perimeter of his executive branch authority, but that sort of middle ground category is presumed to be immune, but that presumption can be overcome by a showing from the special counsel that it doesn't infringe on executive branch authority and sort of undermine executive branch authority. So that is the basic framework they were trying to work within, and it's I just want to say, especially some of the latter part, what would overcome a presumption, very murky in the Supreme Court's opinion, and a lot of the Supreme Court opinion isn't strongly reasoned, so that too makes it hard, even in good faith, to try to get at. Okay, but so now to return, one more overall headline. It's a pretty, given all the kinds of excisions and insistences on immunity from the Supreme Court, it's a pretty aggressive indictment. That is to say, Smith has kept about everything you might have expected he would keep, or conversely, that what has been really thrown to the side and snipped off and left on the editing floor are the things where the Supreme Court's guidance, such as it was most clear, and really there was not much room for debate. So he has forwarded an indictment where there is room for debate, and that's going to matter in terms of what happens next. Okay, but now to dovetail that sketch of the Supreme Court opinion with the superseding indictment. So the Supreme Court did say a president who is discussing investigations, basically anything with the Department of Justice, that is immune. That's a core function, and forget about it. It's out the window. Now, we talked about it at the time. That's a really dubious holding. President Nixon would probably have been immune. The main thing he did was order the Assistant Attorney General in DOJ to order the FBI to stand down from the Watergate investigation. Under the Supreme Court ruling, that would be immune. And likewise, the entire episode where this guy, Jeff Clark, is introduced to Trump by Scott Perry, a congressman, and basically schemed to get this in front of the Georgia election authorities, and it would have been false. And this is where the entire leadership of the Department of Justice, no squishy liberals here, but some very rock-solid conservatives, stood up and said, "We will quit. We will leave if you try to do this. It totally undermines DOJ." So it really makes him, it's a really lurid exercise in abuse and corruption by Trump. Nevertheless, the court says when a president is talking with DOJ and about an investigation, all of that's immune. So the entire thing out the window. Query what happens with Jeff Clark, and is there a way to reach him later? He has been indicted in Georgia, but on similar conduct. Anyway, for today, he's a very lucky beneficiary of the Supreme Court opinion, and let's set him to the side. Okay, the things about discussions with the White House counsel, similar. I think they concluded from looking at the opinion, you're talking with your White House counsel, and we're not going to parse things too finely and ask if you're talking about the weather or the nationals on the one hand, or a criminal conspiracy on the other. That's going to be, an immune sort of core function of the president. That's all out the window. But there's not all that much of that. And then finally, the point I made again and again, Trump is the candidate. His co-conspirators like Rudy Giuliani are private attorneys who are advising him. His tweets, some of them are considered official, according to the Smith analysis, and they are out. But a lot of others are just in the guise of Trump, the candidate, gonna be wild, that sort of stuff. The argument is that's not an official act. That is just unofficial. Okay, and the bottom line is the slimming down from 45 to 36 pages nevertheless leaves all 4 charges, federal criminal charges, still in the indictment. The charge of conspiracy against voting rights, obstruction, conspiracy to commit obstruction, conspiracy to defraud the United States. The actual legal boxes are still 4 and the same 4. And if there's a conviction, that would mean the same amount of time, the same sentence, at least in theory. And basically, you have Smith saying, I can prove my case, my 4 charges, without any of the evidence that the Supreme Court says I can't use. I'm back. We want to do all 4 of them. Okay. What now sort of happens, or what's the sort of middle ground? So I suggested this was fairly aggressive, and it is. And let me give you the number one example and what is likely to be the number one kind of brouhaha before Judge Chutkan. Because now that the indictment is there, they have 10 days or so to file their papers and set up an argument on this indictment about what should come in and what shouldn't. And the big ticket item here, Vice President Pence. So the Supreme Court has a discussion about conversations between a president and a vice president. And it emphasizes that those are really, core down the middle, what a president does, the same way a president talks to the DOJ, talks to White House counsel. However, they they point out, the Supreme Court in the opinion, that the vice president technically wears 2 hats. She or he is at once the vice president, the number one advisor and et cetera to the president, but also the president of the Senate, another role that the Constitution gives her. So I would say most aggressive move by Jack Smith is to try to pigeonhole all the things that, all the criminal conduct involving Pence, including some really vivid stuff with Trump. Basically, if you don't do this, you're a coward. I made a mistake when I chose you. Really berating and browbeating him. The argument is going to be this is in his capacity as the president of the Senate, because it is all aimed at trying to get him to not certify the votes, and that's something he does in his role. So that would be the argument. The argument on the other side, of course, and this is for, super nerds, pages 23 and 24 of the Supreme Court opinion, is that, yes, that ultimate function is Pence as president of the Senate, but the conversations they're having in the Oval Office and things like, basically he doesn't want to call off the mob where Pence is involved, and all those actual assaults on Pence that he really encourages, but all the conversations in particular, that is going to be the real rubber hits the road moment. And now let's talk a little bit about process. So to quickly summarize, the 3 big changes: no DOJ, no White House counsel, and an emphasis on being a candidate wherever possible. But the same 4 charges criminally are still there. And let me just add, all the sort of schemes, there were 5 in the original indictment. He tries to browbeat state legislators like Brad Raffensperger. He's part of the false electors and trying to get people to commit fraud there, which has now been charged in many states, Arizona, Michigan, etc. He does the whole DOJ scheme. That's out. But then he browbeats Pence, and he finally whips up the crowd to a frenzy to storm the Capitol. 4 of the 5 remain in. Okay, and in that 4th, the browbeating of Pence, there's some very, very strong evidence that obviously Smith didn't want to do without, but is going to be front and center in the hearing that is coming up, because Trump will say, just as anything involving talking to DOJ, that's core stuff. So anything involving talking to your vice president when your vice president is acting in his capacity as vice president, and that's really when they're, back of the Oval Office and he's spanking him like a schoolboy. That's him as Trump's vice president, not as president of the Senate. And to my mind, that's probably the stronger reading of what the Supreme Court was getting at. Okay, but what does this all mean? This goes to Chutkan now, and there's going to be big arguments. Let's keep focusing on Pence. Say she agrees with Smith that this comes in because it's got to do with his role and not as vice president, or Even though it's an official act, and this is an important part of the Supreme Court opinion, it doesn't undermine the functions of the executive branch. Good luck with that one, but, it doesn't undermine. So let's say she rules it stays in. And then I'm making this because it would be the most controversial probably ruling she would make. Now we'll have an immediate appeal, I think, to the D.C. Circuit, and the Supreme Court is in the distance. And what that means is Smith, in having a new, fairly aggressive superseding indictment, I think is ready to spend more time. He's been frustrated at everyone wanting this to come out before November, but it hasn't. And at this point, if Trump wins, the whole thing's out the window. But if he doesn't, it's not the same kind of time pressure. So he's decided to go pretty aggressive, but there will be more litigation. The only way there wouldn't be, I think, is if Chutkan rules for Trump and DOJ decides not to contest it. Then they could maybe just go ahead with trial. But I think the treatment of Pence and a few other things in the indictment shows that Smith is ready now to take more time now that we're going to be past the election, if the case is still going to be live at all. Okay, so that's everything in broad strokes. All the same charges are there. All the schemes are there except DOJ. In particular, Pence is there, and that augurs a real battle royale in front of Chutkan. That's coming up very soon, and that's where the fight will be, and it'll fall to Chutkan in the first instance to try to make sense of what is, at best, incomplete and Delphic guidance from the Supreme Court. So there you go. The case is very much alive, but may be very much on a slow track, because we're still going to be talking about immunity, particular pieces of evidence, and potential ability of Trump to take it to the D.C. Circuit and his very friendly U.S. Supreme Court. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.